We're going to have a hard stop, folks, at 6 o'clock. I know a few of you have to leave, and so we're going to try to expedite as much as we can to proceed until 6, and if we need to continue thereafter, we will. I welcome you to meeting number 21 of the House of Commons Standing Committee on National Defense. Pursuant to order of reference of Friday, October 10th, 2025, and the motion adopted by the committee on Thursday, October 23rd, 2025, the committee is meeting to resume its consideration of Bill C-11, an act to amend the National Defense Act and other acts. Pursuant to standing orders, members are attending in person. No one's on Zoom. So before we begin, I ask participants to consult the guidelines on the table. These measures are here to help prevent audio and feedback incidences and to protect the health and safety of interpreters. I'd like to remind members and the witnesses to please wait until you're recognized by name before speaking. And if you wish to speak, please raise your hand. The clerk and I will manage a speaking order as best we can. And for interpretations, use the earpiece and select the appropriate channel for either floor, English, or French. Again, all comments should be addressed through the chair. I would like to now welcome our witnesses. Colonel Genevieve Lautier, Deputy Judge Advocate General, Military Justice Modernization from the Canadian Armed Forces. And Lieutenant Colonel Matt McMillan, Director of Military Justice Implementation, Office of the Judge Advocate General from the Canadian Armed Forces. Welcome you both. I'd now like to provide members of the committee with a few comments on how the committee will proceed today regarding the clause by clause and the consideration of this bill. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is then subject to debate and a vote. If there are amendments to the clause in question, I'll recognize the member proposing it, who will then and may explain it. The amendment will then be open for debate. When no further members wish to intervene, the amendment will be voted on. Amendments will be considered in order in which they appear in the package which each member has received from the clerk. In addition to having to be properly drafted in a legal sense, the amendments must also be procedurally admissible. The chair may be called upon to rule amendments inadmissible if they go against the principle of the bill or beyond the scope of the bill, both of which were adopted by the House when it agreed to the bill at the second reading, or if they offend the financial prerogative of the Crown. During debate on an amendment, members are permitted to move sub-amendments. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. Once every clause has been voted on, the committee will vote on the title of the bill itself. In order to reprint the bill, that may be required if amendments are adopted so that the House has proper copy for use at the report stage. So I thank members for their attention, and I wish everyone a very productive clause by clause as we consider Bill C-11. I know many of you have all of the clauses and amendments to it, so I'll proceed if you're all ready. Pursuant to the Standing Order 75-1, consideration of Clause 1, the short title is postponed. The chair calls now on Clause 2. So, shall Clause 2 carry? Do we have them? It's carried. On proceed to now Clause 2.1. Here, the Conservatives have an amendment, and do you wish to move this amendment?
Thank you, Mr. Chair. I'd like to move CPC 1, that Bill C-11 be amended by adding after line 14 on page 1 the following new clause. 2.1 Section 10 of the Act is replaced by the following. Number 10, the powers of the Judge Advocate General may be exercised and the duties and functions of the Judge Advocate General may be performed by any other officer who has the qualifications set out in subsection 9.1, that the minister may authorize to act for the Judge Advocate General for that purpose, but that officer may act as the Judge Advocate General for a period of more than 90 days only with the approval of the Governor and Council.
Before we proceed, I'd like to note that the amendment seeks to amend Section 10 of the National Defense Act. As the House of Commons Procedure and Practice, 4th edition states in Section 16.75, an amendment is generally inadmissible if it proposes to amend a statute that is not before the committee or a section of the parent act unless the latter is specifically amended by a clause of the bill. Section 10 of the Act is not being amended by Bill C-11. Furthermore, the bill does not seek to modify the appointment process of the Judge Advocate General, which is therefore beyond the scope of the bill. It is therefore, in the opinion of the chair, that the amendment is inadmissible.
And I challenge that ruling by the chair.
Fair.
Je ne sais pas si mon collègue pourrait le répéter parce que ça n'a pas
I
été
don't know if my
enregistré.
colleague can repeat this because it wasn't recorded.
Veuillez répéter.
Avoir votre écouteur, Monsieur le Président.
It's
No,
not.
you just need to use your earpiece.
Je demandais si mon collègue
I was
pouvait
asking if my colleague needs to repeat what he said because his microphone was not on.
I can't hear you.
We're having a hard time hearing. No? The request by our moderator is for you to repeat the amendment for you so you can understand what you're putting forward.
So I am challenging the chair's ruling that amendment CPC 1 is out of scope. It's not up for debate.
Okay? Go ahead to you.
You have to call the question yourself.
Yeah, so it's been forward, a challenge been put forward to acknowledge my decision on this matter.
Is the ruling of the chair sustained? We're going to proceed by roll. If you vote yay, the ruling will be sustained. If you vote nay, the amendment will proceed. Madame Romanado.
Oui.
Ms. Lapointe.
Oui.
Mr. Mallette.
Yes.
Monsieur Watchhorn.
Oui.
Mr. Bazan.
Nay.
Ms. Gallen.
Nay.
Mr. Anderson.
Nay.
Mr. Kibble.
Nay.
Monsieur Savard-Tremblay.
Non.
The results are 4 for the yeas, 5 for the nays. The ruling isn't sustained.
Great, so the amendment is now back, and it's open for debate.
Thank you, Mr. Chair, and I appreciate that. I understand the reasoning why it was out of scope, but I think it's also important that we have a chance to make amendments to legislation and the positions of individuals that are serving, that are named in Bill C-11, who are going to be responsible for the administration of justice. Now, we have had it in the past where the Judge Advocate General was absent for 18 months, and that we were functioning without a JAG other than an acting JAG. And so we find that problematic. We know that Justice Fish, in his original report, suggested that these positions be filled within 3 months. And we already will note that in C-11, that the Provost Marshal, for example, and the Director of Defense Counsel Services, that their positions would be filled within a 3-month time frame, 90 days. So we think that it's important that we expand that to include other positions as well, including the JAG, and for that reason, we are making this amendment.
Open for debate. Jim Watchhorn.
Thank you, Chair. Just a question to the experts here. What's the usual time frame for this type of nomination?
It's something that can take a certain amount of time with the process and verification, qualification, security, and everything. That would bring, like, with the National Defense Act, there's other appointments that are made by the GIC where the minister can appoint for the acting, because this one, what it's proposing to amend, it's not the appointment of the JAG when the position is vacant. It's really about the acting JAG, that the minister could have someone for a certain amount of time, but after 90 days, it needs to be confirmed by the GIC. So you will have other provision in the National Defense Act for other system that has the same type of appointment where the minister can appoint an acting for a period of time, and there's no such time frame. But in this one, it aligned with the Provost Marshal General that has the same for the acting one, the Director of Military Prosecution, and the Director of Defense Counsel Services, who are 3 amendments done in this bill.
Thank you.
Further debate? Seeing none, I put forward this motion, this amendment to a vote, recorded vote. Yes. Ms. Clerk?
Ms. Romanado. Madame Romanado.
No.
Madame Lapointe.
No.
Mr. Mallette.
Nay.
Monsieur Watchhorn.
No.
Mr. Bezan.
Yay.
Ms. Gallant.
Yay.
Mr. Anderson.
Yes.
Mr. Kibble.
Yay.
Monsieur Savard-Tremblay.
Oui.
Yeas 4. Yeas 5. 5. Nays 4. Non. 4.
So the amendment is carried, and we'll proceed to the next clause. Clause number 3. Shall we carry? Clause number 3? We're all good? On division. Clause 4. We have an amendment. Do you wish to move it?
So that Bill C-11 and Clause 4 be amended by adding after line 8 on page 2 the following: the appointment must be made within 90 days of the day on which the office of Provost Marshal General becomes vacant.
Further debate? Yes, Mr. Reminato?
So I guess similar to the previous question that my colleague asked, I just want to know what the normal time frame would be for the appointment of a Provost Marshal General.
So this type of timelines, because it's imposing on the Governor and Council, it's effectively unenforceable because we cannot force the GIC to make an appointment. We cannot force a person that appoints an authority to do it. So to add the 90 days to make the appointment risks to bring legal risk and uncertainties if it's not done within that 90 days. Because you could end up with not knowing if you have a person or the acting, kind of what are their authorities at play. It further brings confusion between 2 provisions. So you have that you must appoint someone within 90 days, and you have another place where it says that the acting after 90 days can be authorized by the GIC. So the act covers the fact that if there's no one and the position remains vacant and there's after 90 days, you need to go to the GIC. So you may have uncertainties between position. If you end up that the person that is the owner of the position doesn't get appointed, and as it has been mentioned just before, it has happened previously with a former JAG that got to the end of their mandate. The person was not appointed because all the authority of the members that were acting under the JAG were really based on someone being in the position. We end up with no legal advisor being able to advise the Canadian forces until a new JAG being appointed. So you can really bring into a place where you may have uncertainties about if you have not the person at the head of the organization.
So in terms of an application then, if this were to pass, what could be one of the ramifications in terms of, as you said, like in the example of someone who has been acting, doesn't get appointed in the GIC? What could be could this delay any cases that are before the JAG? What could be the ramifications if this were to be put in place?
It depending of the position we're talking here, this one is about the Provost Marshal General. Depending of which power we're looking at, there may be no one else that could exercise them other than the person that occupy the office of that person. So also, when we look at, there's a bunch of reasons why an appointment may not be made within 90 days. You could be in election period. You could be the person that apply do not meet the requirement. You could have question of security clearances. You could also have a situation where the person is not available to start within that amount of days because they need to leave a previous job and they cannot be forced to be appointed. So that's all these questions that brings to impose a 90 days on the GIC to appoint.
So on that note, as you just mentioned, should that situation happen, we've heard about security clearances not clearing quickly, and the GIC would have to name within 90 days? And if they didn't, what would happen?
If it's not done, there's no enforcement. So a court will not be in a position to enforce on the GIC to appoint someone. There's no mechanism. If it's not done by the Governor and Council, you cannot force the hands of the Governor and Council to appoint someone.
So essentially, it's not enforceable at all. You can't. It can't be. I don't want to say the word enforceable, but it's moot whether or not it gets applied or not, because even if it were to not get applied, there's no way to enforce that it didn't get applied. Is that correct?
You're right. It's effectively unenforceable.
Okay, thank you.
We did hear from witnesses that we need to put time limitations on these appointments. We heard from Charlotte Duval Laton at the 12th meeting of this committee, and says the challenge is that Governor and Council has not been the most prompt at appointing key decision makers. She points out that took 4 years to appoint the current chief military judge. Took over a year to appoint the current ombudsman, and this needs to change, she said. We heard from Rory Fowler as a perfect example. There needs to be time limits and limitation periods for people to take action to appoint key personnel. He went on, now we're making them political appointees who may or may not be appointed in time. So this requires political leadership. This is a political decision, not a military decision. And Afton David also said, I agree with my fellow witnesses that there needs to be a limit on the time taken to fill governor and council appointments in key military justice roles. So we heard from witnesses on this. We need to put in a time frame. It's not unreasonable to get this done in 90 days.
Mr. Millett?
Thank you, Mr. Chair. After just hearing the testimony from Colonel Lortie on the ability to meet such a time frame, could this not, if to the extent that this amendment is supported, is it not more prudent to apply a modification to the time frame, say to 120 days? That could be an amendment to the amendment.
That's your call.
You want to propose?
I'll so move if this is going to carry, but I don't support it at all, simply because of the fact that a delay in approving an acting JAG can create legal risk and at minimum generate confusion regarding authorities. But should it pass, I guess, the amendment would be.
If I may, Mr. Millett, I think what I'm hearing is that you wish to propose an amendment. If so, just state your amendment, and then we'll go and debate it.
I would propose that this be amended to 120 days on this amendment.
Understood by all? What's being proposed? Any debate on the amendment, the sub-amendment, I'm sorry. Shall the sub-amendment be moved, or carried, I should say? Shall the sub-amendment be carried? Opposed? Well, then we need to determine if it's recorded, so we have to vote on the sub-amendment. It's a recorded vote, yes. So we are voting on a sub-amendment at this point for 120 days. Right? Okay. All right, so the amendment, the sub-amendment is therefore carried. 120 days. 120 days. We're back to the amendment. Mr. Simon, did you? No?
Non, moi, ça va.
No, it's all right. I will vote when it's time to do so.
We're voting now on the amendment that's been amended. Shall that amendment carry? Let's vote. I think we want recorded vote on CP2. As amended, yes. Clerk will proceed.
Madame Romanado.
Oui.
Madame Lapointe.
Oui.
Mr. Mallette. Monsieur Watchhorn.
Oui.
Mr. Bezan.
Oui.
Ms. Gallant.
Yes.
Mr. Anderson.
Oui.
Mr. Kibble. Oui. Monsieur Savard-Tremblay.
Oui.
Yeas pour 9, nays contre 0.
The amendment as amended has carried. We are now into Clause 4. I don't believe there's any amendments there. Shall Clause 4 carry? Clause 4 as amended, yes. Are we in? We're all in, okay, I move that, carried. Clause 5, shall Clause 5 on division carry? Done. Clause 6, shall Clause 6 carry? On division? Done. We're into Clause 7. Now, the NDP 1 is deemed to be moved pursuant to the routine motion adopted by the committee on June 17th, 2020. Oh, wait, nope, my apologies. My apologies, I do have an amendment to that. Okay, if CP3 is moved, NDP 1 cannot be moved, and it is identical. So the new one is CP3, and it's similar to CP1. So, Sal, does the CP3 wish to move?
Yes, I'll move CPC3. Do I need to read all the details? Okay, I shall move that we amend Clause 7 in Bill C11 as circulated. And it's after NDP 1 and CPC 3 and the old kit. So, and just as pointed out, it is identical to NDP 1. You wish me to speak to it?
Yes, by all means.
Okay, so as we heard throughout testimony is that definitely victims were asking for choice in Bill C11 of whether or not they stay within the military justice system or be transferred out to the civilian justice system. And probably the strongest testimony we heard on that came from Helene Lascalera in our 15th meeting. It says, to me, this is why choice is real. Really important at all levels, even if we say that now it was always there and that the choice was possible. Some of them never reported like me because they were scared and knew the consequences. I would say that choice is maybe offered on paper. Is that the case in reality? In most stories that we've heard, it's not the case. Just as Ashram says, I support a system that gives victims a choice. So her answer was yes in testimony. We heard from numerous witnesses, and I'll leave others to speak to it, but they wanted choice. And so if we're going to give justice back into the hands of the victims, we have to give them the choice of which system they want to be handled in their court cases, whether it's within the military justice court-martial, summary hearings, or in the civilian system.
Thank you, Mr. Bazan. Open for debate. Ms. Ramanado.
Thank you very much, Mr. Chair, and I have some questions for our experts here with us today. So I have a few questions, so I'll go one at a time. Could you tell us if this amendment is a trauma-informed approach for the victim, in your opinion?
Thank you, Mr. Chair. Thanks for the question. In relation to victim choice, we've spoken and heard a lot about that at the committee. Participation of victims. What it does in relation to this kind of piece, Madame Justice Arbour indicated that there should no be choice. It puts an unfair burden onto victims. So it is contrary to Justice Arbour's recommendation 5. In essence, it does. It's somewhat of a false choice in relation to a victim, because while it proposes the way the motion is drafted, it says the victim may choose where the matter is actually prosecuted. Ultimately, the determination of where something is prosecuted is the prosecutor's determination. It's prosecutorial discretion. They have the fundamental aspect as a principle of fundamental justice to make a determination on ultimately where and if a matter is prosecuted. So even if a victim chose to have a matter proceed at court-martial in relation to this matter, ultimately it would be the Director of Military Prosecutions which would have to determine if that is the proper venue based on a number of considerations, including what the victim contemplated or what the victim may wish. But that's only one aspect of many public interest factors that would have to be determined in relation to where a matter should be prosecuted.
Based on that, I mean, it's very clear that this is against the recommendation 5 of Justice Arbour, but based on what you just mentioned, would you agree then that this is not a trauma-informed choice? This is not a trauma-informed approach, that this would be left to a victim to decide, but doesn't actually have the ability to decide because it is the prosecutor who decides whether or not to lay charges. Is that correct? Am I understanding that correctly?
It would be difficult to determine it. It would be difficult to determine at the end of the day. The victim may make a choice that they want to go one way or the other, but ultimately that choice is not ultimately theirs at the end of the day, because the prosecutor will make that determination. So they may choose to say, I wanted to go at the court-martial system. And once the matter is brought towards to the Director of Military Prosecutions, ultimately they will make the determination if it will go to court-martial. So at the end of the day, while a victim might assume to choose, their decision can't fetter the discretion of the prosecutor. So they're going to be left with the burden, I've made this choice, and it's now not proceeding to the actual court-martial in itself because of the determination of the Director of Military Prosecutions.
So on that note, I can imagine a victim, as it, like in the example you gave, said, I would like this to go into court-martial, and the prosecutor, after reviewing the case, decides we're not going to pursue it. I can imagine what that would do to the victim is it would almost re-victimize them to say, I made the wrong choice. Whereas if I had maybe gone to the civilian, maybe the prosecutor would have pursued it. Could that happen?
For certain, it could happen. One of the issues with the motion as it's before me is one of the determinations that need to be made is the jurisdiction at the outset. This is dealing with Section 70, so Clause 70. You still have Clause 80, which removes the jurisdiction of the military police to investigate. So in essence, what will happen in this situation is the civilian police will investigate the matter. If they're investigating the matter, they are going to pursue charges in the civilian system if they deem it to be reasonable in the circumstances and want to proceed with charges. The civilian police do not have the authority to lay charges within the court-martial system. So in this instance, the civilian police would investigate. They can't, if the victim then doesn't want the matter to proceed in the civilian system, they would have to look for an avenue to bring it back to the military justice system. And in that instance, the civilian police would not be able to actually lay those charges. So it would be a charge-laying authority within the military justice system that would have to proceed. And in that instance, it's going to be either the military police or a member of the chain of command that has the authority to lay charges. They may or may not have access to the investigation of the civilian police, and they themselves have to make the determination that they're going to proceed with laying charges. Ultimately, they're going to, not to put words into a police's mouth, but I would suspect that they're going to look to probably interview the victim again in that instance. So with the lack of clarity of where it's going, it puts a burden and potentially a situation where the victim will be questioned on multiple occasions from multiple different organizations that have an interest in the matter. First, the civilian police that have jurisdiction to investigate, and potentially another mechanism once the determination was made after the person was charged to try the matter in the military justice system. And on that front, just based on how subsection 2 is drafted, it speaks about the person that's charged under section of those offenses. The civilian police, as I said, would lay charges under the criminal code. The court-martial does not have jurisdiction to try matters under the criminal code, only under the code of service discipline. So those charges would be withdrawn by the police or the prosecutor and then relayed under the code of service discipline pursuant to the criminal code. That's very technical in the sense, but court-martial deals with code of service discipline offenses. Civilian court deals with criminal code offenses. There is an overlap based on how the code of service discipline is drafted. That's how all criminal code offenses and any other offense under any other law is brought within the code of service discipline. But it's not as simple as just charges are tried in one place or the other. There's a mechanism and a framework that have to be followed in order to advance that prosecution.
You also mentioned something about the principle of prosecutorial discretion. The way that this amendment is drafted, would this be constitutional?
There would ultimately be a question in the end whether or not it's constitutional. It purports to say that the victim may choose whether the person charged with the offense is to be tried by a court-martial or a civil court. That purports to fetter the discretion of a prosecutor. In that sense, there's questions about whether or not it would be constitutional. Ultimately, at the end, even if they choose one or the other, it is the prosecutor that would ultimately make that decision, which then gets into potentially some challenges for the victim in relation to the decision that they had made at the first instance. Really, the jurisdiction should be determined at the earliest onset to avoid these challenges.
Thank you.
Thank you, Mr. Renato. I have Mr. Anderson, then Mr. Savard-Tremblay, Mr. Kibble, and we'll proceed. And
Thank you. In the civilian system, the prosecutor ultimately decides whether to go forward or not. Is that correct? So it's the same in the military. Either way, either prosecutor in the military or in the civilian system could decline to prosecute. Is that correct?
The prosecutor will decide if it proceeds to court-martial or not. You're right that in the military we have the same system. It's really for the court-martials.
Yeah, so that has no real bearing on it, whether the civilian system or the military system. Either one, the prosecutor has the discretion to do that.
Both systems, you're right, have a discretion. Here what we're looking at is that the time where that choosing is proposed, charge have already been laid. So it means a decision has already been made. And what you're going to encounter, it's challenges under the Jordan delays. So we know it's something that it's applicable to both court, the civilian court and the military court, that you have 18 months to get to the end of the trial, and the time start from the laying of the charge.
Okay.
So that provisions start from the beginning that the charge is already laid in one system, in the civilian, and they want now to go under the military justice system. So to do that, that's where all the steps that has been described by my colleagues need to happen, and that's a process that takes time to review the file, to get legal advice that are required, to lay to the point of the referral of charges to court-martial. So one of the first challenge you could get are with Jordan delays, because you start in one and you need to get out of one and get with the other one.
With regard to Jordan, the Jordan decision, we've heard from the military prosecutors and the military defense, and we've heard from the chief of police of Victoria. The military says they have the capacity and the capability. The the civilian system says, essentially through the chief of police of Victoria, that they have the ability but not the capability. They simply can't take on this sort of work. So, I mean, I would suggest to you that the Jordan system would, or the Jordan decision would impact much more frequently in the civilian system. I just want to point out here that and I can read the list of witnesses, but we've all heard them. Everybody except for one asked for choice, including the experts and the victims in here. And I'd like to point out something that Dr. Karen Breek said. First, the military of 2025 is not the military of 2015 when all of these reports were. Many problems identified in the Deschamps and Arbor reports no longer exist. Today, the chain of command has extensive awareness and training. The Sexual Misconduct Support and Resource Center is fully operational. Victims' rights legislation is in force. Independent legal and victim supports exist. The duty to report has been removed. What evidence still shows the recommendation 5 remains the best way forward? I would suggest that things have changed dramatically right now. People still are asking for choice. Victims are still asking for choice. And I find it, frankly, paternalistic to hear Minister McGuinty sit here and say that it's a false choice when it is an obvious choice. It is the civilian versus the military. It's not a false choice. It's a choice that the victim deserves and should have. Thank you.
Thank you. Mr. Savard-Tremblay.
Oui, à la lumière, effectivement, des témoignages.
Given the evidence that we heard, many witnesses suggested free choice and being able to ask the military system. But later I'll have an amendment, BQ1, which I think is a better kind of compromise. So I'll be against this proposal, but I think mine is in the same vein, but it's more realistic. Mr. Kibble?
Mr. Chair, I have a couple questions and comments. Yes. Are we on here? Yeah. That I'd like to share. Lieutenant Colonel McMillan, are you, you made reference to the Constitution. Are you a constitutional law expert?
No, I'm not.
No, okay, thank you. And you also mentioned about trauma-informed training. Have you taken a trauma-informed training course?
I have.
You have, excellent. I have as well. And I'm glad to hear that, and that's very wonderful. You know, one of the things that they talk about is choice or freedom or being constrained. And so this would be a legal restriction, and it would certainly feed trauma by taking away choice. Would you agree with that from a victim or survivor?
In relation to this aspect, it's a question about whether or not a victim can participate in making the determination. Ultimately, when we're speaking about this motion, it purports to make a choice and the sole choice for the victim. That's the concern with the motion, because that's not how the system functions in relation to, as we spoke about earlier, prosecutorial discretion.
Thank you. I find that interesting. The Canadian, in relation to what you've said, the Canadian Association of Chiefs of Police provided a written submission to us, and it said, quote, the proposed provisions in Bill C-11 would deny victims and survivors the ability to express a preference as to how their complaint might be investigated. This approach departs from the victim-centered and trauma-informed principles that underpin the best practices in policing. So that sounds very contrary to that, and it certainly speaks to choice. And I think it's worth repeating as well that my colleague, Mr. Anderson, has stated the majority, the overwhelming majority of the survivors that we've spoken to, as well as the witnesses that we spoke to. Of course, Justice Arbor, from her report from many years ago, 10 or plus years ago, you know, at a different time, had stated otherwise. But you know, the survivors and the witnesses that we heard, up-to-date information, testimony in this very room, spoke to choice, and I think that's the way forward. And in our times, I'd also like to explore quickly. You said about multiple times telling the stories. They'd have to say once in a civilian world, or sorry, once in a military format, and then if they switched, they would have to say it twice. I would, from what I've heard from an overwhelming number of survivors and also from personal experience, I can say that a victim or survivor would be saying their story multiple times within just the military justice system at each level as they progress, as they report. So it's not you know, there's these claims that they're going to have more suffering because they have to say the story twice. right? And they say their story over and over and over, so much so, then they want to get their voice out and told that they come to committee and share their story here, or they write about it in a book. They tell their story over and over, and I think it's a bit of a false flag argument to say, oh, well, they're going to have to say it twice. The survivors that want to make change and see improvement, and they come forward and they make the argument, they tell their story over and over, as heartbreaking as it is for them, they feel compelled to do that. So I don't think it is an undue burden. And I'd like to conclude with a quote from Heather Vanderveen, who also did a written submission after speaking to us here. Survivor autonomy is one of the strongest predictors of recovery after institutional betrayal and sexual trauma. Bill C-11 risks creating a system where survivors feel processed through the system rather than empowered within it. And it's that empowerment, the choice, that speaks to trauma-informed theory, and that comes from trauma-informed training, as we've heard from the Canadian Association of Police Chiefs. So I think that while you state that, I think the overwhelming testimony clearly indicates that. Thank you, Mr. Chair.
Thank you. We have MP Idlout with her hand up at this point, and I think we require consent from the committee to allow her to speak. Is that correct? Mm-hmm. So do we have consent to allow Ms. Idlout to have her say? Please, over to you.
Thank you to the committee. I would have spoken to these issues given that CPC3 is exactly the same as NDP1, so I do appreciate the opportunity to speak and ask questions regarding CPC3. Specifically with this bill, we did hear criticisms that this bill didn't directly consult with victims enough, so I'm glad that we heard testimony from several victims, from veterans as well, regarding procedural matters as well. I know that I wanted to make sure that I recognized the testimony that we heard from veteran and PhD candidate Helen Lewis-Kellia and Christine Wood, who both spoke to the importance of making sure that victims can have choice in which courts would hear them. So I wanted to mention those two during this committee as we consider this amendment. I also wanted to ask the witnesses if that's okay, because we've now seen the Liberals table Bill C-16. And Bill C-16 looks to make an important amendment to the criminal code regarding how some procedures happen, especially regarding criminal harassment. And I think this bill has the potential to be impacted by Bill C-16 if 16 passes, given that C-16 makes an amendment to the criminal code regarding harassment provisions, where we know that the current harassment provision, Section 264 of the Criminal Code, has both a subjective and objective requirement, and C-16 would make a change to that so that when it's obvious that there's been a victim who's been harassed criminally, that she doesn't need to prove for herself that she feared for her safety through criminal proceedings. And I wondered if you had a chance to look at Bill C-16 regarding criminal harassment, and whether that Bill C-16 would have an impact on this bill, and how victims would have to could use 16 as a way to protect themselves.
Bill C-16, the Department of National Defense have been implicated in the drafting and the working until the tabling of the bill. There's a specific amendment under the National Defense Act, and we were fully aware of what Bill C-11 is bringing to the table for amendment to under the National Defense Act, though that's been completely considered. When we're talking about an amendment for an offense or the way to prove the offense under the criminal code, those one only gets incorporated under the military justice system, under one of the provision that incorporate all the offense under the criminal code and the way to commit the offense. So not every provision needs to be amended. We don't have a copy of everything under the National Defense Act, but we were fully aware and we completely participated in the working and the amendment being proposed for the National Defense Act that are incorporated under C-16.
Ms. Lapointe, you're up next. I have you on. Yeah,
Thank
I
you,
got
Mr.
Ms.
Chair.
Lapointe, then Mr. Bazin, then Ms. Gallant.
I'm wondering if you could tell us how important it is for investigators to know right from the onset which system has jurisdiction in the case that they're about to investigate.
So at the first step, when the investigation starts, they may not necessarily know which evidence will be able to prove which offense. So it's really like two-step system that, depending of what they're looking at, they will consider who has jurisdiction. In that case, it's proposed to have investigation under the civilian justice system.
Can you tell us what kinds of issues can arise in an investigation if the jurisdiction isn't clear from the onset?
They need to know if they have jurisdiction to maintain, because as soon as they start investigation, they need to know if the evidence will be maintained, it will be admissible, and that all the action that they take can be justified. They need to have jurisdiction to get to the next step. That needs to be determined early on as the first step.
Okay. Thank you.
Thank you. Mr. Bazin.
So we talked about the prosecutor has control over the direction that charge is laid, whether it's civilian or in the military court. Well, we did hear from the Director of Military Prosecutions, Colonel Kerr, said, if it wasn't for the tabling of Bill C-11, I would have already rescinded my direction to stop exercising jurisdiction in these cases. I'm really prepared to resume accepting appropriate cases in the military justice system now. He goes on, I believe victims in the CAF are better served by retaining a concurrent jurisdiction over these offenses. Victims deserve a say in where their cases are heard, and I'm concerned that some cases will not be heard if jurisdiction is removed. That's from your own Director of Military Prosecutions. Then we also had the Brigadier General Hannaran, who is the Provost Marshal General, and she said at any point in the process with concurrent jurisdiction, there's an ability to have a choice change. A victim, for example, in the beginning may ask for a military police investigation or vice versa, a civilian police investigation. And during the course of that investigation, they may change their mind and ask for something different. Concurrent jurisdiction allows us, from an investigative perspective and a prosecutorial perspective, to work with the victim to help them work through those choices at any point along the process. So there you have the Provost Marshal General and the Director of Military Prosecutions saying that we need to have that choice and that there needs to be concurrent roles in both. If they want to go civilian, let them go civilian, but if they want to stay within the military justice system, let them stay there. And that's what we heard from victims, was they want this choice. So the idea, and I think that the best place, rather than going with the block motion, which is in Clause 8, Clause 7 is a place where you can give choice early on, right off the bat, with the investigation, with direction to military police, and direction to the Defense Council Services and the Director of Military Prosecution, to ensure that that choice is available right at the get-go. And Clause 7 is the best place where that takes place. So when you hear from multiple witnesses, and in both writing and in the testimony that we heard, we even heard from the CDS. General Kerrigan actually said it. It's ensuring that victims are enabled and that they keep agency over their own process and how they want to go about their own complaint. Even the CDS said that when she appeared on C11. So that was in the very first meeting that we had on this. This is reading right out of her quotations from, the staff are shaking their heads. I'm reading right out of the minutes from the meeting. And so, we can circulate them to you because it's right there. And so if you want to make sure that we are providing choice, if we're standing up for victims, or if we're going to make sure the military justice system works, we're going to keep jurisdiction when they're out of Canada, but then we're going to wash our hands of it, it doesn't make any sense. And I think, as we heard from witnesses as well, that they just believe that this is the department and the Canadian Armed Forces, that those in leadership just want to pass the buck. Rather than actually having a system that works for them. So I just encourage everyone, if we're going to do the right thing, if we're going to stand up for witnesses, if we're going to stand up for what the witnesses said here as victims of military sexual trauma, then we better pass this amendment and give them that choice.
Thank you, Mr. Bazan. Ms. Gallant, over to you.
Thank you, Mr. Chairman. I have a question. And if a charge is laid, but the prosecutor decides that there is not enough evidence to go forward, it's evident that something did happen, but they can't get a decision that from the judge in the civilian courts. Does that mean that the perpetrator is just off the hook, or is there a fallback that the military would investigate, take the evidence, and still make some type of charge militarily?
For some offense, when it's as a prosecutor, when it's you may lay a charge of sexual assault, but you can prove.
Can't hear you. Sorry.
If you have a charge, if there's a charge laid of sexual assault, the moindre inclus, so the one that is included, could be someone could be found guilty of assault. So when there's one of the elements that is not being proven in court, so that's one of the possibility. If a prosecutor decide to not get furthered because they don't have a reasonable prospect of conviction and the charge is withdrawn, yes, it's possible that other type of offenses could be looked at.
Through the military system.
In the military system, we have the inclusion of all the criminal code offenses, but there's other typical military offenses that are only of a military type that could, depending of the fact that are proven, but other type of offenses that could be laid. The names are escaping me right now, but if you remember that.
There's disgraceful conduct. There's the slew of offenses that are in the Code of Service Discipline would be available if a matter is investigated by the military police and they determine that there is a reasonable basis for laying that charge. Yes, they could do that. So whether or not they investigated it is a question mark based on their jurisdiction to investigate, depending on the fact. It would really depend on the facts of the case.
So if the victim was definitely assaulted and there's evidence of assault, but because it's a sexual assault and the prosecutor cannot find reasonable chance of conviction of a sexual assault, are you saying then it would go through the military system and the individual would be court-martialed and go through for assault?
They could look at it, the prosecutor could look at it as the assault, and the military system would maintain jurisdiction for pure assault charges under the criminal code. It's not one that is proposed to be excluded here. So yes, if it's what is discovered in the evidence, the investigation body can discuss, and that's when a file could make a way back in the military when we're talking about investigation to complete the investigation, the laying of the charge of something for which the military has jurisdiction.
Thank you.
Okay. Ms. Raminato.
Thank you very much, Chair. I have two questions. I know that Justice Arbour had met with hundreds of victims and spoke to them, and I know that in the previous Parliament, the Standing Committee on Veteran Affairs also did a study with respect to military sexual trauma in veterans and issued a report to the House of Commons entitled Invisible No More. And in that report that was voted on in the ACVA committee and tabled in the House, it said in recommendation 40 very clearly that jurisdiction for military sexual assault investigations and prosecutions should be moved to the civilian system, which is part of the reason why this bill came about. But one of the issues that you mentioned in terms of concurrent systems, you mentioned the Jordan principle. And so should a victim go forward in one system, start the process, then decide to move to the other system, you mentioned that the victim would have to start over, correct? And that could cause problems vis-a-vis Jordan principle, that every time there is a change in venue, there is an additional length added to this process. Is there a risk at any point that should this happen, that a perpetrator could walk free under Jordan principle?
There's a clear potential for a breach of the Jordan delay, considering that the way the motion is drafted, it starts with a charge that is already laid. So it means that we have already decided, jurisdiction has already been decided. The way it's being proposed now, it's start in the civilian. As soon as a charge is laid in one of the system, if you already have entered a plea, you need authorization, leave of the court to withdraw a charge. So that's something that is on the prosecutor to do. When you get it, and let's say it's been leave with the court, you transfer a file to a military police member. They now need to understand completely the file, to have a reasonable belief that an offense have been committed. So it's not a question of necessarily an hour or two. It may take time. At that point, they don't have jurisdiction to continue further investigation, so they have the file that they have. If they lay a charge, because civilian authorities don't have jurisdiction to lay a charge in the military justice system, they lay a charge, it gets to the director of military prosecution. Before they lay the charge, they need to get legal advice, because that's the kind of nature of offense that will require them to get legal advice. Get legal advice. There's a reasonable, sorry, I missed the, they have a reasonable no. They believe the offense have been committed. They lay the charge. They transfer it to the director of military prosecution that needs to review the file, need to do the referral, and gets to the court martial. So that's a system that takes time. I've been a former prosecutor. I've faced unreasonable delay charter application, and that's certainly a case where, because the timing start from the laying of the charge, so it start not from the delaying in the military, that would start way back under the civilian justice system. 18 months, you can certainly get there, and that could certainly be challenged. And if we end up that with unreasonable delay, that would be a stay of proceeding that the court martial could declare on those charges.
Oh boy. Okay. Thank you. Thank you for clarifying.
Mr. Anderson?
We've talked about theoreticals and potentials for delay. I want to read a quote here from retired Colonel Michel Drapeau. Most court-martials normally don't take such a long gestation period to see the light of day. In the civilian court, sometimes it's going to take 4, 5, or 6 years before it comes to trial. So, I mean, those are, you know, we can talk about hypotheticals, but in fact, that's it. And I'd like to go on and read some quotes from Minister McGuinty himself. This is about a suite of targeted amendments to help bolster confidence in the military justice system. That is a statement by the minister. In response to, I don't think the details, again, one of the reasons we're here is that we're very open to hearing more from all members about how to improve this bill. We've heard of a lot of them, a lot of people. All of the victims, save one, say they would like choice. All of the experts say they are in accordance with choice, and the choice furthers the independence of the victim and the feeling of, and I can read those quotes as well, if we wish. The point is, if we're trying to make it better for victims and make a more fair system, we don't want the offloading onto the civilian system when the civilian system is saying, no, we don't want it, we can't deal with it. This is simply downloading problems onto them so that we at the federal level don't have to deal with it anymore. That is not good for the victims, that's good for us. And I would argue that the victims have spoken very loudly, the experts have spoken loudly, and I don't think there's even a choice. I don't think there's even a debate here to be had. We can go into technicalities, which we've been doing in hypotheticals, but that's as far as the case can go on the other side. I think choice is imperative here. Thank you.
Mr. Bazan, it's up to you. Then we can probably go into a vote after that, folks. Mr. Bazan?
So first of all, I just again want to say that, we heard multiple witnesses, written submission by Jessica Miller says the approach of C11 does not recognize the unique nature of military sexual trauma and the institutional structure of the CAF. Jurisdictional transfer risks reducing accountability, weakening discipline, lowering conviction rates, and failing to deliver justice to survivors while removing responsibility from the chain of command at CAF. Christine Wood, limiting as far as a single pathway to justice weakens our agency rather than strengthens. We want to be clear. She's not defending the status quo. She says the military justice system failed me too, but replacing one system that's broken with another system that completely and consistently fails victims of sexual offenses does not create justice. It simply reallocates the problem and it removes CAS responsibility for fixing it. And we heard from all other witnesses that the problem here is that CAF needs to provide leadership on this issue and not just pass the buck, and that's what we were looking at with this. I wouldn't mind just getting first a quick interpretation, because the block had mentioned that they believe that their block 1 provides a better balance than CPC 3. I'd like to get your interpretation of block 1, since they do kind of overlap, if that's in order. To have that comparison on whether or not Block 1 actually does provide that, since in this situation, my understanding is that we're already in the civilian system. Military police have already not done the investigation, and it's going to be the civilian court that will have to send it back to CAF or court-martial under bills or under the amendment in Clause 8 that they're proposing in Block 1, BQ1.
BQ1, some of the same issue would come back. When we discuss about possibility of an unreasonable delay under the Jordan principle, we could end up at the same place, considering that it's starting under the civilian justice system. It also goes against a principle where the civilian system and the court-martial system have been recognized as being separate but equal in nature. That motion would propose to have the civilian system to decide for the military. I think it's certainly something that could be challenged. We look at it, but there's issue that had been identified about
Point
the
of order?
authority.
I believe that we're not supposed to be discussing an amendment until it's actually been moved, and BQ1 has not been actually moved, so I think it's a little premature to have that conversation. I don't know if they're going to move it.
Yeah, we are talking about the amendment put forward by Mr. Bazan. Mr. Bazan?
I'll just, on that point of order, just refer everybody to Chapter 16 of our brand-new House of Commons Procedures and Practice, and I encourage everyone to read it. It's riveting, especially Chapter 16 and Chapter 20. So on page 645, it says, the chair may permit debate to range over several other amendments which are interconnected or which raise different aspects of the amendment under consideration. These are definitely connected, and I see the law clerk is also nodding yes, so I would like to have this debate.
It's confidential until it's moved.
This has been published.
Seeking 3 is identical to NDP 1. The block's amendment is slightly different. But
But they are interconnected. It all deals with choice.
understood. I will proceed to complete Mr. Bazan's discussion, and then we'll move on to Mr. Kibble, if that's,
So are you going to let them
yes,
continue
please,
on?
by all means.
Yeah. On the comparison.
Thank you. So if we continue further, so what I was mentioning is the doubts that we could have about civilian authorities to decide for another system were clearly within the division of power. Also, if the civilian court were to decide that the court-martial would have jurisdiction, it doesn't mean that the court-martial would take jurisdiction in a case. So you could still end up at the same place where, even if the civilian system decide, and we're at the court at that point, decide to that it should be addressed under the military justice system at court-martial, the court-martial could reach a different decision. And it's all the same principle about, we're talking about the charges already been laid. So all the delay and the implication of going from one system to another one would be similar to what we explained previously.
So you're actually making the argument then that we keep it all into the military justice system so that we don't have those delays and the Jordan framework doesn't come into play. Mr. Chair, based upon, like, we've had a lengthy debate on this, and I know there's more questions than answers. I don't think we're in a position to make a decision on this, so I would move that Clause 7, Clause 8, and the associated amendments be stood.
Well, we do have a few more speakers on this very amendment. I believe Ms. Normandine wants to speak to it as well.
I think I got a motion on the table.
And there's a motion before the table, so we need to, we need unanimous consent in order to proceed with that motion. Do we have unanimous consent? No. So, Mr. Kibble, you're up.
Thank you, Mr. Chair. My question is for both of our experts that are supporting us today, and thank you for being here doing that. Were you involved, either of you, with the drafting of C11? Or do you have that connection to it?
We participated in the working of the development of this bill.
Okay, fair enough.
Yes.
In the denial of choice, which I would like to refer to my previous comments, that would be a trauma uninformed denial there. But in the denial of choice, what would happen in the case for minor or gray zone, as was brought up in testimony cases? We've heard from numerous victims or survivors who supported choice, but said that they would not necessarily want to go to civilian, and they would want to keep it within the military, and others the opposite. And we also heard from multiple police testimonies, and I can certainly bring up the quotes later, that many of the cases, especially in the minor or gray zone areas, would not even go to civilian prosecution. And so what would happen in those cases? What would be the justice for those victims? As was stated earlier, the minister testified that this was to restore justice within the military and the image of that. So are they not going to be prosecuted for more minor cases that the civilian police will not take?
There's always the prosecution discretion. So for every case that they face, it will really base on the circumstances of the case. Sometimes if a more major offense is not proven, they can have other offenses that charge could be laid and prosecuted. So in every case, you will have in both systems a discretion with the file.
Okay.
And they each have public interest factor that they need to consider, and those one would be different from in the military than in the civilian system.
Bluntly put, the testimony that we heard was a groping example that clearly the civilian police would not prosecute, that the civilian courts would not prosecute, and yet in the military system that would be prosecuted and establish discipline and order and punishment for that type of behavior. So would that just be then a free pass for people to do that? And how, as what the minister's goal was to restore justice and trust in the military justice system, what happens in those minor cases?
So each time that you have the prosecution discretion, we don't know in advance. It's really when they have the file and they review the different circumstances of the file that they can decide. In the military, we still have administrative measure that can be taken against a member. So that's always another
so-
option that remains.
So you would, the military, for those minor cases of groping, and I don't like to get into the actual levels of detail, but I think we can all agree that there's these minor or gray zone cases that are absolutely unacceptable within the military culture that we've all identified here and agreed to that needs to change, and those are going to be dealt with administratively. That doesn't make sense. That's like a free pass for those people. They're not going to be prosecuted within the military justice system. We know that the civilian justice system is not going to prosecute those. This seems like a failure if we implement the trauma uninformed denial of choice in C11. It's going to be a free pass. You're going to get administrative choices. I'm well aware what those administrative choices are, and it's very minor in comparison to the military justice system. I think that this would be a travesty and open, complete free market or free pass for these perpetrators. It should not be in. And we heard multiple examples from victims and from police that exact scenario would happen. This is completely opening a can of worms. And as my colleague said earlier, that this shouldn't even really be for debate. It's this amendment is really a no-brainer after hearing all that testimony from the police. I mean, even the police chief from Victoria, where the second largest base is, they simply, and this speaks to the comments that we heard on the Jordan decision earlier, which is being used as a defense by our experts here for this bill. Under the Jordan decision, the Fiona Wilson, the police chief, said they just don't have the capacity in the civilian system to deal even with major cases that would come out of CFB Esquimalt. So that would cause all these cases not to be prosecuted, let alone all the minor cases, which we don't have an answer. How is the military going to deal with these minor and gray cases? So I contend that really this is an absolute no-brainer. We have the testimony, overwhelming from the survivors, overwhelming from the experts, that this is the best way to proceed. And, it's both trauma-informed. It will support the minister's guidance that he wants to see military justice system restored and people to have trust in it. Allowing a free pass, that doesn't achieve that in any way, shape, or form. So I contend that, that this amendment needs to be dealt with. It will bring the justice that we need into the military system and restore that and not let people get away with things in the very culture that we're trying to change. Thank you.
Thank you. I have Ms. Galland and then Ms. Normandine.
Okay, so given your response to my last question, I just recall that we had a witness, Jasperini, who had been forced into a broom closet and raped. Her career ended, the perpetrators went on, and he admitted the sexual assault. There were no court-martials, no consequences at that time, and he went on, and he had raped other people, and the military police knew about it. Nothing was done. So I'm concerned that even though there are other avenues through the military system, that it might not happen if there's not reasonable chance of prosecution in the civilian system. So my question is, because you said that the amendment as written would not permit the timing for the victim to have a choice once the charges are laid. So is there another way to word this so that there would be a choice on the part of the victim, but having to do with when the charges are actually laid?
So jurisdiction needs to be established before that point of laying of a charge. So that's when the timing of the Jordan delay starts. It's the charge is laid. So any time before that would not be considered in the to be considered unreasonable or adding to the time when it's before a charge is laid.
But before a charge is laid, they can't make a determination on whether or not it's civilian or military.
depends how the provision are drafted. So what Bill C-11 propose without that amendment is really, it's in one system, so you don't have delay from transferring from one side to the other one. That's in line with Justice Arbor recommendation number 5 to completely remove the jurisdiction. And there's 2 steps. There's the investigation, that's clause 8. We're still on under clause 7, that is the prosecution with the link to the court martial.
But there's nothing compelling the military to enact consequences on the part of the perpetrator should the charges not proceed because or a trial not proceed because there's not reasonable expectation of conviction.
Sorry, I'm not sure I understood completely your question. I'm sorry.
So there is not the opportunity to ensure that something is going to happen militarily through the military justice system if the civilian system decides not to proceed with the prosecution, it's just dropped.
There's no certainty. There's a possibility of something, but there's always, we're back to the prosecution discretion, and they need to look at the file, the circumstances, and to look at the reasonable prospect of conviction. It means to establish every element of the offense and the public interest factor to prefer a charge to get to court-martial. So it needs to happen in every case.
Thank you. Welcome back, Ms. Christine Normandy, to National Defense. Over to you.
Merci beaucoup, Monsieur le Président. Merci.
Thank you. And thank you to the witnesses. Colonel Lurtier, I have 2 questions for you. You talked about the jurisdiction of both courts, the military and the civil one. If we were to maintain the victim's choice to go with one or the other, could the martial court refuse jurisdiction? Even if the civil court said we think it should go to the court martial. The way the provisions are expressed, these issues of jurisdiction depend on what we'll find in an act. Currently, in the National Defense Act, there's no aspect talking about the preference of a victim to go into one system or another. So it's a concurrent jurisdiction. So we have to know who will exercise that choice according to circumstances. So if the victim decided to go through the civil courts and then changes their mind to go to the military court, could the military court refuse? I don't think it would be refused as such, but it has to be established very clearly in the Act how, if there were a choice to go or not. The version says that the victim makes the choice. If we take it to the extreme, it would mean that we don't respect the independence. If the victim chooses one or the other, you don't have the choice, prosecutor. You have to go into that system. And then that doesn't respect the basic systems of independence and prosecutorial discretion. So that could be contested in the courts. So if that's a choice and it's imposed, so we don't have the choice to go ahead. So do we have all the evidence to go forward? If we skip that step, well, it's an argument that could be made. I understand that's a bit of a possibility of a forum shopping. Is that what I should conclude from what you've said? If we talk about a choice, there's a difference between choice and preference. In vocabulary, if we're saying we choose something, if the other authorities cannot exercise their discretion, they're being prevented of doing that. And these are considered fundamental legal principles in terms of discretion. So maybe this seems very theoretical, and we wouldn't want it to happen, but something that could happen if for a same incident there were several victims, and if there was a victim for the victims to choose the forum, what could happen to the hearings that would be happening both in civil court and in the court martial? Can they proceed in a concurrent way with the same person being the defendant, but with victims in two different courts for similar facts, without a person being able to be judged twice for the same actions? So there can be concurrent jurisdiction then to saying that this trial has can work on civil issues or not. In one system, there can be joint processes if there are different people who are accused, or if one person is accused, there are various types of accusations or charges. So if we talk about the same event but with different victims, the procedures would go separately.
Merci, Christine.
Then we can go to a vote. Thank you. Pardon me? Unless, yeah. Mr.
Thank you, Mr. Chair, and really I will save this address for the room in general and the members opposite here. For our experts, I appreciate the answers for questions, although here as experts to answer some technical questions, I do feel it was a lot more like testimony in support of a bill that they helped draft and in defense of that. And I just wanted to put that on the record for you, Mr. Chair. Look, the goal of Bill C-11 is very well intentioned. And I think we've all agreed that, and we've seen that there's culture changes that need to change, and I think we're all very passionate about this because I truly think that everyone in this room is more focused on getting something right for the survivors, although we have differences of opinion there. And the goal is to restore trust in the military justice system, to provide justice for victims and how we achieve that. But it's also to improve the culture. And I will say I have seen improvements for the safety and for the culture in the Canadian Forces, although there's more room to go. I know when I joined many, many years ago, some of this type of culture was terrible. 25 years ago, or it's okay, longer than that. I don't want to say how long ago. And there has been improvement in years of recent, but it still has farther to go. And I think that if done right, Bill C-11 can help us achieve that. It's also to provide trauma-informed safety, choice for the survivors. So it's while restoring military justice and improving the culture, respecting those needs. C-11 without the amendment or choice that we are presenting, without our CPC-3 amendment, it doesn't provide a solution for the survivors in terms of minor and gray cases. It's opening a Pandora's box that could destroy the good progress that the CF has made and worked very hard for in the last several years. It would reverse that. And as we've heard today, it would be forced to resort to using administrative measures versus military justice measures for dealing with minor cases that would not be prosecuted at the civilian level. And we've heard much testimony about those middle, lower, and gray area cases that would just be left now, as we've heard, to administrative. And that's not a way, that is not trauma-informed, that is not going to improve the military culture, and it certainly will not restore trust in the military justice system. That's the stated goals. We've also heard from the civilian police that although they're beyond capable, and I have full trust in Fiona Wilson, the chief of the Victoria Police Department, in their capability, and she stated they have that capability for dealing with the major cases, they do not have the capacity. And her question asked, and I brought that question forward to the minister, I believe, how much funding is going to be made available for the extra police officers that were required, and this was specific for Victoria, but I thought that was a good example because it is CFP Esquimalt is in there, and that's a large base. So there was no answer. This bill, as it right now, without the amendment, it doesn't provide the funding and the training, the extra that's going to be needed. There's a lot of money that's going to be needed, and we heard examples of how long these cases can take, both the investigations and the prosecutions. And there would also be a lot of training. There is no plan for the training. Our amendment solves that issue. Our amendment doesn't require a solution for the minor and the gray cases because there's already a system in place that will deal with those. And I contend and I look at everyone straight in the eyes and seriously say that the military administrative system is not designed to do that and will not be able to deliver that justice. Okay, I understand how the administrative rules and steps take, because I've applied those myself. For administrative issues, not serious issues like sexual misconduct, whether they're minor, whether they're gray. That just simply doesn't suffice. So without the amendment, that is not solved. It's not trauma-informed, and I don't want to beat that one too much, bang that drum, but we've discussed that. It takes away that freedom, and that's also one of the goals of C11 that's not achieved. And I think giving that choice is going to make it trauma-informed. So I'll conclude with, without Bill C11, without our amendment, without CPC number 3, which I'm imploring that everybody consider to vote and support so that we can deal with restoring military justice like the minister wants, so that we can improve the culture, continue that improving culture that has been going on over time, and so that we can provide compassionate, trauma-informed choice and support for the victims, as we've heard overwhelmingly. Okay, I would love to do the math on this, and maybe I'll do it for next time we sit down, the percentage in terms of comments that we heard from experts, from victims and survivors, from people that deal with victims and survivors. Overwhelmingly, that's what we heard. So on behalf of my constituents, in my riding on Vancouver Island, where there are many, many veterans, because we're adjacent to CFP Esquimalt and have CFP Comox to the north. And I know that from all the people that I've met, whether I've been in this job or before. So on behalf of all my constituents, of all the many survivors that I personally know, the many survivors that I've met through doing this job and through advocacy work that I've done, through Wounded Warriors Canada, through all types of advocacy work that I've done for veterans, I know them well. I will be voting to support our amendment number 3, and I would ask everyone to consider for the reasons that I have given. Thank you very much.
Mr. Bazan, your hand is up.
Yep. So, you know, I think the idea of transferring all cases into the civilian system is a bit of a hope and a prayer. And, you know, we heard from the Canadian Association of Chiefs of Police in their written submission that they strongly recommend maintaining concurrent jurisdiction. The proposed provisions of Bill C-11 would significantly hinder collaboration between civilian police agencies and the Canadian Armed Forces military police. You know, we just have witnessed the government come in with their gun grab, and in that we have had several provinces now, and municipal and provincial police forces saying that they will not participate. And so if they are saying no to the federal government on the gun confiscation, why would you think that they'd want to take the time and extra resources to also handle stuff that has traditionally been done through the military justice system? We have now, and through C-11, this new duplicity, where, you know, if it's going to happen within Canada, we're going to hand it over to the civilian courts, which are overrun and have their own problems with the Jordan framework, and lower levels of sexual misconduct aren't going to be handled. We don't know if information is going to be properly shared between the reports to civilian agencies and into the chain of command and into the military justice system, whether or not summary hearings are going to be able to take place at the same time as civilian court cases are being heard. What happens on the administrative penalties for those that are accused? We don't know how this is all going to play out, so it's a bit of a hope and a prayer. That, you know, hope that the civilian system has the capacity to deal with it. You hope that provinces are going to want to participate. We hope that it's going to bring justice for victims. And, again, a comeback that we've heard from almost the majority of our witnesses who are victims of military sexual trauma, that this isn't going to work. And, Donna Van Lutzen said it's about having choice, having some agency, recognizing there are some crimes that would be prosecuted within the military system that would not be prosecuted in the civilian system. I do firmly believe that it's a mixed thing, but I do think it's progress that we're looking at. Christine Wood said, I originally completely opposed the transfer of all cases to civilian court, and that was for 3 reasons. Number 1, it's broken. Number 2, it offers victims no choice. Number 3, I believe the CAF has to maintain control over its jurisdiction and demonstrate it can be responsible for fixing its own harms. So, I really do think that, we need to pass CPC 3. And I think that, the NDP, the Bloc, and Conservatives all want to make sure that the victims' right to have choice in how their cases are heard, investigated, and tried has to be maintained. And I don't believe that, CPC 3 and NDP 1, which are identical, that CPC 4 going on, CPC 5, and NDP 2, Block 1, like they're all work together. And I don't believe that any one of them passing would create the other one to be out of order. I think that in all cases, and I'd ask the legislative clerk this, that is there any or amendments that are made here that would force other amendments, again, connectivity between amendments that would force any of these to be out of order and then not deemed admissible.
There's a question that's been posed to the legislative clerks here to determine.
Point of order, not while they're conferring. Given the hour, maybe we could check with the clerk to see if there's any possibility of us getting additional resources past 6. I think that it would be helpful to continue this conversation.
We got a hard stop.
I just want to know if it's possible for us to get additional resources.
I gotta fly, guys.
Let's go to a vote.
Yeah. I'm prepared to stand it, and we can come back to this. I don't mind moving through the rest of our legislation. This is an important piece of legislation. This is about standing up for victims.
Okay,
No,
guys.
I'm just saying that we need to make sure that we get this right.
So let's stay later. Happy to do that.
Let's put this through the chair, please. Quorum, do we have a response for Mr. Bazan?
Procedurally, it's fine. If there's any content, that's for the officials.
So procedural is fine if there's any content. Okay. Should we go to the next speaker, Mr. Bazan? Are you done?
I think that, we should pass these pieces of these amendments as we proposed, and I think that we can build in really strong choice if these amendments all carry, right through what's been proposed up to BQ1.
Bear, we are now. We do have Miss MP Idlout. You had your hand up, and I believe Christine now has her. I'm sorry, Miss Normandine has her hand up as well. And if we could move to a vote before this deadline, I don't really want to extend this beyond 6 o'clock. So over to you, Miss Idlout.
I just wanted to reiterate how important it is to listen to the victims. I think it's also a rarity where the Conservatives and the NDP agree on an issue. It's quite rare, and we have both our parties. We've submitted the same amendment, CPC 3 and NDP 1, and I think this goes to show how important the victim's choice is, especially given in their circumstances. They would have lost so much, having been victimized by such horrible acts against their integrity, especially in the military. in a male-dominated industry, we have to do what we can to make sure that we're showing our support for victims, and especially veterans who shared with us. I'll say their names again: Helen Luskelia and Christine Wood. I do remind this committee, for example, Helen said, I'll quote a portion of what she said to the committee. She said, "The third issue is choice. Survivors must have the right to choose between civilian and military systems at all times, regardless of location or rank. Choice is not procedural, it is freedom. Freedom from our aggressors and freedom from the silence that institutions have imposed upon us. I want to be clear that even with this choice, neither system is sufficient on its own. The military system understands the operational context. The civilian system provides independence and oversight. This is why I believe the real reform must move toward a joint hybrid investigative system that is culturally informed, trauma-informed, independent, and capable of protecting survivors everywhere in Canada and in deployment environments. And finally, what Christine Wood shared with us, she's also a veteran. I'm absolutely opposed to the transfer of military sexual offenses to the civilian justice system. I support the creation of an independent system of justice for sexual crimes within the military. I support it because the Canadian Armed Forces must uphold their own good order and discipline. That responsibility is essential for transparency and accountability. Limiting survivors to a single pathway to justice weakens our agency rather than strengthen it. We want choices. Kuya Namit, Chair.
Thank you. Normandine, you're the last one, I hope, so that we can proceed to a vote. Thank you.
Merci, Monsieur le Président. Je vais peut-être
Thank you,
malheureusement.
Chair. Unfortunately, I might disappoint you in part. I'm very supportive of Mr. Bazan's arguments, saying that we're all here with the same intention. We're coming to do this work in a state of respecting the victims. And unfortunately, some things seem to be contradicting this will. The question of Mr. Bazan to the law clerk, I was interested to know that procedurally there's no incompatibility between CPC 3 and the possible BQ1 amendment, but I'm concerned that there might be incompatibilities at the legislative level. And these are questions, and maybe I'm addressing Colonel Lortie about this, and I feel our witnesses could answer. So I feel uncomfortable about going ahead with CPC 3 without having minimally spent some time on the possible incompatibility at the legislative level between the two. So I'm wondering if it's possible to have a few minutes of suspension so we could discuss this with our colleagues, because we're really dealing with a very specific issue at the legislative level. It's much more so than procedural. And if we have a bill that's not well set up for the next 5 years, I think we owe it to the victims to do this. So that's the request I'm making.
Legalities and the legislative and the procedural aspects of this. I am sensitive to time, and we may have to continue this if we suspend. So if the committee is of that opinion to satisfy Ms. Normandine's requests for clarity on those issues, 3 minutes, is 4 minutes good enough? Because then it'll take us to 5:45. Suspend.
CAF members into the civilian justice system. This approach does not recognize the unique nature of military sexual trauma or the institutional structure of the CAF. Jurisdictional transfer risks reducing accountability, weakening discipline, lowering conviction rates, and failing to deliver justice to survivors, while removing responsibility from the CAF chain of command. So that was Jessica Miller, and that really speaks to the point that I was making about the gray zone cases. And I think this is, of all of my previous words that I gave, I think that is the biggest part, the biggest concern that I have is that those gray ones will be reverted to, as we've heard, administrative justice through administration, not justice through justice. And I think that that is a huge mistake. The second quote was from Justice Deschamps herself up at our 16th meeting that we had. And I think this is really, really important words to hear. It says, "We therefore have a few reasons to believe that low-severity misconduct will not be prosecuted in the civilian system anytime soon. As I explained in my report, the culture of sexualization emerges through many small day-to-day actions. If these small actions go unchecked, a culture of impunity takes hold and opens the door to more serious wrongdoings. I therefore believe that transferring jurisdiction for offenses of lesser severity involves significant risk." And that's Justice Deschamps. And in fact, I would contend, although she testified that it would involve significant risk, I think it would just remove completely the prosecution of that and justice for that, and it would only be dealt with through administratively. So the CF positive changes, culture changes, I contend would simply reverse and without this amendment. And that would be tragic. And that would be the exact opposite of what we are all trying to achieve together. And that's why I'm so passionate about that, because as a veteran, I think that the CF does some amazing work, truly amazing work. But this is an area that needs to be fixed, and I want to see it fixed. And I don't want to see that reversing. And, you know, without our amendment, you know, that will be on C11, that will be on us as a failure, on all of us, if we're not able to bring that choice in. So I will certainly vote for this amendment, and my conscience will be clean, knowing that I did everything I can to provide a trauma-informed, justice-building, culture-improving change that, as the bill stands, it will not have, and I think will bring very tragic consequences. So, you know, I think that's about all I can go for now, but thank you, Mr. Chair.
Mr. Gibble,
give me a couple more minutes and I'll put something else together.
And Mr. Millett, you're up.
Thank you, Chair. I do have some questions then on jurisdiction and this provision for our witnesses, in particular to Colonel Lortie. There has been some suggestion that the provision does not explain what happens if a victim refuses to exercise their discretion in choosing a forum. Can I get your take on that, please, Colonel?
Yes, so there's a possibility if there's no choice expressed, because it's really between one or the other, so we could be in a limbo and have unclarity into what could happen.
And as well, without related motions amending Clause 8, as they pertain to investigations, this provision only provides victims with the choice concerning the forum of the proceedings, but not choice as to which police authority should investigate. Would you agree?
Yes, so the way the bill is drafted, under 7, we're talking about the prosecution jurisdiction, and under Clause 8, it's all the investigation. So it's really two different levels of discretion that they have. So those, the way they're written, they go in pair, certainly. And if I could add, the way the provision is drafted and it's renumbering it, it would require many more amendments for each time the provision are listed when we refer to them. So there's probably kind of another handful of amendment that would be required to refer to those provisions each time.
It's been also in some of the legal advice that has been expressed that any amendment to the bill that raises possible challenges to the system, in fact, and this may be a little extreme, but risks the military justice system actually grinding to a halt. The military justice system, in this assessment, is vital to maintaining the maintenance of discipline, as we've heard in testimony here, and the efficiency and morale of the CAF. The result of any of these could possibly be an impact on the operational effectiveness of the CAF itself. As I said, it's a pretty dark view, but any opinion on that, either yourself or Colonel McMillan?
So it's clear that each time if the system brings uncertainty, it could certainly erode the confidence in the military justice system. We need to have a system that is clear and predictable on jurisdiction for everyone. That's something that is essential. It can create friction in the system if there's uncertainty where not to go. It may not be used also at that point, and it can also weaken the Canadian Armed Forces discipline and efficiency that are essential to maintain operational effectiveness of the Canadian Armed Forces.
Parfait, thank you.
Horn.
Merci, Monsieur le Président. Moi, j'aimerais...
Thank you, Chair. I would like to bring to the floor slightly divergent opinions concerning choice. My colleagues on the other side have said that several witnesses had said that choice is a better option. I would like to show quotes from witnesses to the contrary, two cases in particular. The first was Charlotte Duval-Antoine, who says, I want to emphasize what Ms. Arbor said in terms of Recommendation 5. In fact, leasing to the victim the choice of the jurisdiction puts them in an untenable situation. If the affair doesn't unfold as they wish it, they're traumatized by the following question. Did I make the wrong choice? This creates serious psychological distress for the victim. I'd like to ask the two experts here whether they agree with this. For the application of work with the victims, I'll leave it to other people to answer. So the second quotation by Professor Megan Mackenzie, she says, I insist on repeating that the idea that having a choice is preferable for the survivor is inexact for the most of the victims or survivors that I speak with. When they've had an incident of sexual violence, it's very difficult for the survivor to understand the consequences of that act and the complexity of the choice. Many survivors want to be in the military justice system, not because they think it's better, because it's a system in which they find themselves. That is the institution in which they have trust. After this decision, the survivor would have wanted to have another option if they weren't satisfied from the choice that was proposed to them. We know, thanks to the study I mentioned, that there are examples of plea agreements in the military system in cases of serious sexual aggression that allowed the people to plead guilty to lesser offenses in order to avoid being found guilty under the criminal code.
Before I ask concurrence to adjourn, I just want to thank Lieutenant Colonel, for your service to Canada, for your experience, for your dedication, for your expertise in these matters. And I know you care about the victims, and you care about the armed forces, and you care about the judicial system and the proper way to proceed. And your process and your enablement today is one of care for your service, not for any political party, as may have been insinuated. So, sirs and madam, thank you for your service to Canada. With concurrence from the committee, I'm going to adjourn. We'll proceed on Monday. Meeting adjourned.